is a resolution appropriating up to $10,000 from the Common Council Contingent Fund for the purpose of securing outside counsel in various matters relating to the Milwaukee Police Department. This is file number 170587. Alderman Perez.
Thank you, Mr. Chair. This was, I guess, a way to figure out what the next steps were in regards to the March letter that Alderman Kovac, Stamper, and myself sent to the chief regarding the Collaborative Reform Initiative report. And we didn't hear any response. In May, 9 Alder Common Council representatives signed a letter kind of asking where it was at and how it was going to move forward. And we didn't receive anything until July 21st, which was a, let me get the proper date here.
13th.
The 13th. We received a note saying that because the Department of Justice did not, said that it was their property and couldn't share it, that I thought to myself, we should kind of have a conversation around us having our own counsel in order to respond to the denial, just because the little bit I know and informed by some of my colleagues, even the city clerk's office, that that request or that denial, could be refuted, and knowing that that there had been conversations between your office and the chief regarding our requests, that same to the conversation we've been having, that we felt we needed our own representation to fight the denial.
Yours was not the only request made for this information. I think that there are several others. Yes, we did participate in working with the department on the response letter, not in terms of the issues or the report itself. I don't think we've ever seen the report, but just legally, how do you craft a letter response like this? So if there were litigation, again, following my opinion, I would seek to represent the chief in that litigation because we believe it is a valid response. Whether the substance of the response, the balancing test, is in favor of the chief or in favor of those challenging it, I don't know at this point. It may very well be that I would be conflicted out such that the council would have to retain lawyers for both sides. The other comment I would make is that $10,000 is going to get you nothing, absolutely nothing. If you're going to bring a lawsuit like this, let me just refresh your recollection about a recent lawsuit, a similar lawsuit brought against Sheriff Clark, in which Voces de la Frontera sought certain records from the sheriff, ICE records. That lawsuit was brought in circuit court. The circuit court ruled in favor of the plaintiff and against the sheriff. The Court of Appeals ruled in favor of the plaintiff against the sheriff. The Supreme Court reversed and said, based on statutory law and ICE's position that those records could not be released, the Supreme Court ruled in favor of the sheriff. I don't know I haven't spent a lot of time with that case. I don't know the extent to which it is precedent, but I think it suggests that a lawsuit to challenge what the chief has said and the reasons why he has denied the record would be a difficult lawsuit to bring. Also, if the case ends up in the Wisconsin Supreme Court, you are talking about significant legal fees, significant legal fees. There was another case in circuit court within the last few months, maybe the last year. I forget who, if it was the sheriff. They're seeking records. The DA asked that those records not be produced. And based on the Supreme Court decision, the judge agreed that the records should not be produced because of the request of the DA. So I'm just pointing those concerns out to you.
Mr. Chair. I've actually made the request for you to provide an opinion on whether we could fight this and you're going to represent our office. We've sent that to you, so now I guess we need to know whether you're conflicted out. It feels that way if you're giving them advice on how to respond to a denial, but maybe someone else can answer that. So we've made the request for you to represent us in this, or at least give me an opinion about the legality of the denial.
I don't recall that that's exactly how you
Okay.
presented the request, but I will certainly do that. Understand that our role is to tell a custodian of records the legal requirements in providing a response. We do not advise on whether or not to release the records or whether or not to take the position the custodian took in this case to deny the records. We just tell them how legally to formulate the letter.
Okay, thank you.
Yeah, Mr. Chair.
Alderman. Wait, are you finished, Alderman?
Yes, I am.
I find this whole situation utterly ridiculous in the sense that open records law shouldn't even apply to this situation because there's one government it's a government trying to get a record from itself, basically. But that aside, I do think there's a untested legal principle here which needs to be clarified, and that is whether a third party's draft in the possession of a city official is somehow not subject to disclosure under open records, because that's essentially what you're arguing, a third party's draft, and just because they claim it's their property, well, so what? That's the open records law is intended to clarify that, and if it's not clear now, I think it needs to be clarified for future reference. If a developer gives me a document that shows draft and it has confidential information in it, and they give it to me, and the Milwaukee Journal-Sentinel business reporter demands that document, that's discoverable as far as I'm concerned.
Unless there's a confidentiality agreement when you got it, yes.
Right. Well, okay, I have another solution to this. I agree, $10,000 won't get you very far in this arena. Fire and Police Commission can demand, through a directive, the release of this draft report to them. They can examine it in camera, in a confidential closed-door session, and they can determine whether all or parts of it can be released to the elected board of directors of the city. Correct? Mary Nell, would you like to come back up and respond to that inquiry? Then nobody is incurring any legal fees, and if the chief continues to refuse, then instead of suing him, you discipline him for refusal to respond to this directive. Correct?
Well,
that doesn't cost anybody anything.
a directive has to be supported by hearings and fact-finding and the ability to have the chief, has the requirement of collaborating with the chief.
He's the policy advisor.
So,
In issuing a directive or developing a directive, the chief is the policy advisor to the commission.
Under state law, or that's just our custom?
State law.
so theoretically, yes, there could be a directive, but we
Aren't you, as the executive director of the Fire and Police Commission, aren't the commissioners interested in what the Department of Justice has to say? I suspect we will never see the content of this report, ever, because of the change in administrations. They're out of the business of reviewing police departments. Maybe that's a good thing, maybe it isn't. But we do know that a document exists which has a lot of information relative to a variety of issues, not the least of which are civil rights issues and impacts on minority communities in the city of Milwaukee. And I would think we ought to know that for purposes of guiding our future policy making and our dealing with our constituents and informing perhaps who the next police chief will be and what criteria we'll use to hire that chief. The fact that everybody is comfortable to just, well, my head's in the sand and I like it there. I don't want to know too much, I find totally unacceptable. And if there's not a will to hire outside counsel, which we clearly could do, because that does cost, that is money. Certainly, the Fire and Police Commission could make this issue a directive, and let's try that route, or try both routes, then see which bears fruit. I find it absurd. Now, the mayor hasn't seen this supposedly. I asked the chief, has the mayor seen this report? No, the mayor doesn't want to see this report, because ignorance is bliss in this arena. If you don't know there's profiling going on in the city, you can't be accused of ignoring it. I think there's a desire not to know what's in this report on the part of some officials in the city. I'm not one of them. I would like to know what a third-party evaluation found, because all I hear is anecdotes, all I hear is complaints at community meetings, all I get is nasty emails about they did this, they did that, I was stopped, I did nothing, and it's all anecdotal, it's all episodic, and it's I feel unable to respond to any of this, other than to say, file a complaint with the Fire and Police Commission, which seems so inadequate. But it does appear to be the only remedy in individual cases. Here we have a systemic review that has been undertaken by professionals in this business. Presumably, conclusions have been drawn, and we're told, you can't see it, and I'm never going to show it to you. And if that's acceptable as elected officials,
well, I don't know that was said. I don't know how long that's. I mean, I don't know how long this is just going to go. I've seen pieces of it.
You have?
Well, not of the actual report, but I've seen what some of the recommendations may look like. But I'd like to. I don't want to go through an inquisition from you, but I would like to make a comment from whoever has the gavel.
I have the gavel. Mr. President.
Thank you, Mr. Chair. So here's the deal. There is no adversarial relationship over this issue with the police department. The chief is willing to come, explain his position. We've had a number of conversations with him about the contents of this report. It's absolutely important to understand you mentioned some of them in your comments about whether or not the complications of getting the contents of the report out is dealing with some of the staff changes and administrative changes with the DOJ. There were at least some communications back and forth from the experts who were here actually doing the report, and the contents, just factual ones, not opinions, not changing the content of the report, but just getting information straight. And so it was my request to the chief that he actually come in closed session at Steering and Rules with the majority of the council members there to explain some of the details surrounding whether or not it would be advantageous to just release a draft report, and have that floating around, considering some of the lawsuits that we're facing right now. And he's perfectly willing to go through the report, the contents of it, with council members in closed session, just so you can understand the conversations with the DOJ, where they are in the process compared to other cities, and also, if we're so concerned about the constitutional ramifications of what may come out of this report and actually implementing some of these recommendations, we don't need a report to actually start implementing some of the recommendations around 21st century policing strategies that have been suggested by the DOJ as it was under Eric Holder in the Obama administration. We don't have to wait for a report to start implementing those recommendations. And so it seems to be a sideshow for me if we're going to spend so much time talking about a report, a draft report at that, as opposed to taking the recommendations that are kind of national in their application and start implementing those, and let's fight toward building toward that direction, because that would mean something.
I agree. Let's implement them. Well, why aren't we?
Actually, we are. We're in the middle of a summer of implementing some of the major recommendations right now.
Let's get the information and let's implement these recommendations. What's wrong with both?
And which is why this is just a little premature. I mean, like, if we're unable to do those things, then, okay, then we have something to actually hang our hat on and say that we're in an adversarial relationship where we actually need legal representation in order to do that. I don't think that we're in that space yet.
Of course we are. We've made a good faith request for a document that we know exists.
But you haven't gotten an explanation as to why
Yeah,
that
we have.
request.
He's met with us. He gave us the explanation. And
So-
we don't accept it. That's adversarial by definition. Courts have to sort that out. Who's right on the law?
Okay, so I would prefer not to do it on an individual conversation that he's had with an individual alderman, which is why
Two of us were in the room, and he...
Alderman, let's let people finish, all right? I mean,
And so-
they keep talking over each other.
Yeah. Thank you, Mr. Chair.
Mr. Chair.
And so what I would suggest, just as a way of kind of putting something substantive on this, is that we allow a full discussion of the release or non-release of the draft report in a closed session, with council members there in a position to be able to ask questions and dig into the details as to why that would or would not be a good idea.
So that'll be at the next hearing and rules, then, right?
Yes.
So, and it's my understanding in private conversation with the chief too, and I don't think this is public information, is that the Department of Justice have sent them a letter saying that you cannot release this information, and so, I mean, we're all frustrated because we were, the chief made the initial request for this study, correct? And we all felt it was important, all members of the council, and we like to see it. And I think there's legitimate fear that it could get buried because of change of administration. But that does not help local police departments throughout the country. Milwaukee's not the only one in the same picture. So I think the president's make the appropriate request, and it's going to come to steering and rules, and I think that's the next approach to take. Alderman Perez.
Thank you, Mr. Chair. I agree. It doesn't have to be adversarial. My biggest issue was, we're almost at the end of July or middle of July when we got anything at all. And the request to come see us and briefly talk about this report didn't happen on its own. It happened at your request. And I'm not sure what's in the report, and I'm willing to hold this item, but keep it open in case we do need to go there, we should. And maybe we can amend the amount so that we have an adequate amount of funding to make sure it's appropriate.
So motion is appropriate. Move to hold. Alderman Borkowski.
Well, I don't know if this is actually on the motion to hold.
You got a little leeway. Go ahead.
Thank you, Mr. Chairman. And you, Mr. Chairman, in our previous item, just talked about how important communication is. Okay, this is the first I'm hearing that the president has seen parts of this report. We've all been very, very frustrated, and there's some of my colleagues that have taken the leadership position and flushed this out. But the long and short is that, we all know that we want this information, and, why aren't we talking to one another? And what we're going on, our basis is that there's a pattern of the chief ignoring the council. That's reality, okay? Because interestingly enough, you want to talk about irony? Well, he doesn't report to us, so he basically can ignore us. So what group does he report to? Fire and Police Commission, and now all of a sudden he doesn't want to report to them. It's an incredible, ironic statement. But the long and short of it is that why are we just hearing now that, we're going to have an opportunity to talk to the chief about pieces of this report? I'm speaking for myself. I thought we were totally shut out. So evidently, I guess I'm not hanging in the right offices or whatever, but communication, is a two-way street, and I'm clearly not part of any kind of discussion, so I'm venting.
Well, the motion is appropriate to hold. Is there any objections to
Mr. Chair.
Alderman?
I just want one question on the motion and just a couple general comments, if you'll give me leeway, too. The question on the motion is, do we have the option, because there is this closed session of steering and rules coming up next week, or is that this week? Okay.
Next week.
Next week. So, and then this is a monetary file, so it would have to be referred to Finance and Personnel. If this committee holds it, I'm not sure, then it gets transferred. As a practical matter, depending on how steering and rules goes, if 8 members of the council or 10 members or 15 members of the council would want to proceed with this at council at the end of July, and it's somewhat, given that we don't meet in August, that's why I'm asking, would we have the, maybe it's a city clerk question, I don't know, but would we then have the leeway to pass this, or because it's a, do we need, does this need to go through committee, or can council act on this, as long as it's been introduced and held in committee?
I mean, in terms of appropriating any dollars, it'll need to have another committee meeting, but I'm not going to be an obstructionist. Now, I may not agree on this track of pursuit of legal action against the chief, but I'm certainly not going to be an obstructionist, and I'll work with the president to make sure that there would be a special Judd-Legg hearing, so at least there'd be an opportunity for a debate on the floor. But, I mean, I do take seriously, we have some, at least appears to be some precedent court case with the Sheriff Clark going all the way to the state Supreme Court, and, this seems very similar in terms of my lack of legal training, but it seems fairly similar analogy that here we have a government asking for a law enforcement officer for reports that are being told by the federal government not to release them, and then I mean, the appellate courts are supportive, but, the Supreme Court hasn't. And that'd be a lot of money to waste with taxpayers. So I think the pressure for me would be, let's put a resolution going forward for immediate adoption on the council floor, calling for our congressional representatives, including Senator Johnson and others, to reach out to the Department of Justice to put some pressure on them to release this report. I mean, that's what, our congressional representatives can do, and maybe get that report out. I mean, it's to their benefit that this information gets out to the community for all parties, and then not just Milwaukee, but nationally. I think we have to put some pressure on our congressional representatives to at least go in from that angle of attack. But I certainly would not be an obstructionist, and I'll work with the members. Alderman?
I just want to be clear. My motions to hold is, one, because of the closed session as steering and rules, and also to give an opportunity for the city attorney to respond to the letter we sent last week. And if things don't go the way as planned, then we'll revisit this.
Okay.
Mr. Chair?
Alderman?
Just a couple general comments I wanted to make on this, since I think it's important to get some of this discussion out there as public as possible, which is always our intent. First of all, add to the ironies that Alderman Borkowski said that I actually agree with everything Alderman Bukowski just said. So layer that on.
Mark the tape. Mark the tape.
Yeah. So
lightning round around.
This controversy has brought us together. But I do think, I did meet with the chief at the chief's request, which may have been at President Hamilton's request. I don't know what, or may have been at the city attorney's request. I don't know why the chief was, for the first time in 9 years, willing to come meet with aldermen in their offices. It finally happened. The concerns expressed by the president, I understand those concerns. The potential factual discrepancies in the report, which was raised by the chief with me and was raised here by President Hamilton. And for me, the clear analogy here is the audit process. We have an independent comptroller who will audit departments, and that's also a collaborative relationship. There's a back and forth, but there's also a paper trail of that back and forth, which isn't a paper trail of every single email, every single conversation. On Wednesday they said this, on Thursday they said this, but there's generally, the comptroller presents an audit of findings, and then there's an appendix of a department response. We get that with every single audit. Now, the usual response is, thanks for the advice and we'll implement it, or thanks for the advice and we won't, but occasionally the departmental response is, actually the comptroller got it wrong. And sometimes the comptroller comes to the table and says, yeah, we missed a fact there. I mean, there's no shame in being wrong, especially when new information is presented to you. So to the extent that there might be factual errors in the draft report from last fall, I'm not afraid of the public not being able to sift that out, especially because the police department would certainly have the opportunity to provide their own, whether it be formal or not, appendix, as it were, to say this fact happens to be wrong. I think we should trust the public and the advocates to sift through that if there are indeed factual errors. So to me, that's not a reason to not release the report, because there might be mistakes in the report. Something else that the chief said in his letter of denial is that he doesn't want to be forced to regularly provide work product materials in an incomplete form. And I would agree with that if the word regularly. Like, if we were to just start routinely, as a council, demanding that every communication our chief has with the DOJ be given to us, well, then that would probably impair both the chief's and the DOJ's ability to work collaboratively if they knew that every single communication they were ever going to make would be asked for by a public body to be released to the public. But I think it's pretty clear the uniqueness of this circumstance. I think if the president in 2016 was the same president in 2017, which it couldn't be because he was term limited out by the Constitution, but just hypothetically, if this was the same DOJ in 16 as in 17, I don't think there'd be any, I think we would all say, hey, hurry up if you would, because some people in the public are getting impatient. But we get a draft is a draft and a final is a final, and work all this stuff out. That way we can avoid the appendixes. So we'll just wait for the final, give us a time frame when the final will be ready. The problem is, as Alderman Bauman indicated, the Holder Lynch Justice Department has turned into the Sessions Justice Department. And Sessions, this is not speculation, he's made public comments saying we're out of this business. At the time the chief asked for this report, I think all of us supported the chief in asking for this report. It was in the wake of a number of high-profile incidents, as well as some systemic complaints that Alderman Bauman alluded to. And I think we all were hoping for a collaborative effort. And I think when you look at Chicago and Ferguson and many other cities around the country, I think you saw the Holder and Lynch Obama DOJ making efforts to improve, not to shame, but to improve police departments through their third-party expertise. And we all thought that was the attempt here. But we're now worried that given the change in administrations, it's going to get swept under the rug. And so this idea that what the chief has basically claimed is, yes, we had a complete draft, and now we only have piecemeal updates to the draft. Okay, I mean, I don't want to get too technical or legal, but sure, you don't have a complete subsequent draft. All we've asked for is the complete first draft. Or we don't even know what we're asking for because we don't even have it. I mean, if there's a substantial difference between the complete first draft and piecemeal updates, I mean, we can have a conversation about what would be best to release and how. But what we got was an official denial letter, which my suspicion is if the chief wanted to release this, he could, and I think that his conversations with the DOJ would probably have led to a different letter if the chief wanted it released. That's just my suspicion. I don't know that for a fact. But my guess is the DOJ will probably not be enjoining us one way or the other, although I'm not sure about that. My guess is, especially because whatever the current leadership of the DOJ ends up saying, it's different than what a previous DOJ would say, and the whole world knows that, including Jeff Sessions. So I don't think that Jeff Sessions is going to be offended by things that Loretta Lynch said 9 months ago. I think he'll say that's what a different DOJ said. I'm saying this, and I don't know if there's any danger in releasing that. And so it seems to me there's a clear public interest in getting the information out, given the unique set of facts I just described. I don't think anyone should be reasonably afraid that this is the beginning of opening the floodgates of every conversation our chief ever has with the federal government will now be subject to a complete, transparent it has to be public. We want there to be private conversations, working relationships, draft, but this is not that informal. This is a formal draft report that I think there is strong public interest in seeing, and also seeing the department response to, and third-party responses to, or at this point it would be fourth-party responses to a third-party review. And I think whatever's in that report, and I have no idea what's in there, we're in more danger by not releasing it through the suspicion and speculation that will come forward, of what people don't know. Getting what's known out there is always better than allowing people to wonder what might be out there. So I think it's a strong public interest to get this information out. And certainly I don't want to spend a single taxpayer dime in court, certainly not at the Supreme Court level, trying to fight this. I don't like that it's adversarial, but it frankly it became adversarial when we got the denial. The chief created an adversarial situation, and then in addition, the chief now has his own outside counsel on a different matter, but we'll see how that all plays out. So that would just be my comments on, I think it's in the strong public interest, and I think the council, there's different strategies for how we can get that report out. Actually hiring outside counsel and actually suing the chief is the least best strategy, but it's better than just sitting on our hands and not letting the report get released.
Mr. Chair. Tell us how you really feel. Go ahead, Alderman Prokowski.
I have a point of clarification, and that is that we're coming in into a weird week because Stern Rules that was scheduled for July 20th did not happen. And so we have council 1 week from today, the 31st, of which then we go into our August recess. Was the intention to have Stern and Rules before the 31st? And I've been made aware of the fact that many of my colleagues are on a fact-finding mission to Detroit later this week. And so I'm curious as to when the Stern and Rules, is it going to happen then after the recess?
So we were intending to have the special before the next council meeting. Because of the trip and the way that things kind of fail with the timing, because we wanted this to be the only thing on the agenda with the special to allow the discussion to be what it was. So it would probably be after the recess if we were unable to get the calendars together.
Okay, well, just knowing what I know, I mean, this week sounds almost impossible, so and then we meet as a group 1 week from today, so we are looking at the very least September.
We cannot, this closed session will not be before our next council meeting?
Right.
What about Monday? Can it be scheduled Monday?
Monday is the council meeting.
Oh, and
Monday's the council meeting.
Well, we could, I suppose, have a special council.
Well, I don't know what point a council meeting would be. I mean, it's just going to be a communication.
Yeah, I mean, we could, I'm just saying we could, depending on what the will of the council is.
Doesn't matter. There's no action we could take. We could pass 200 resolutions. They'll be ignored. I mean, so as a practical matter, unless we're willing to stiffen our backbone here and say, hey, this is important. We want to see this information. So we're going to just be told no and sent on our way, basically, as the elected board of directors.
The maker of the motion has requested it be held. Now, as I said earlier, I'm not an obstructionist. I mean, I will schedule a special jet lag before Monday if necessary, but I'm going to listen to the sponsor of the motion who requested it be held right now. And the reasons he gave were, I think, pretty valid. So, we can take it one step at a time, and we'll go from there. At this time, is any objection?
Do we have a date for the actual steering and rules then? Yeah, I heard next week.
No, we don't have a.
So you think it would be in
date for it.
September?
Yeah.
But you said after the recess?
So it would either be after. I mean, if there is enough interest, we can see about the availability before we actually left for Detroit, and that leaves tomorrow and Wednesday. So, I mean, those are discussions that we can have.
We already have a special meeting tomorrow, right?
At 1:30, we have a special Public Works Committee meeting.
With the availability of
September
members.
is fine. I mean, as a practical matter, nothing's going to happen between then and now anyway.
Well, I'm not giving up putting pressure on the congressional side. I think we should really reach out to them. I mean, this is a very hot topic, not just for Milwaukee, nationally. I mean, the Trump administration, especially under control of Sessions, this is the streets of this country deserve to have a response on these issues. So at this time, Alderman Perez moves to hold and hearing. No objections, so ordered. Thank you.